And where are we on this case, folks?
Your Honor, we've had a few hearings on this. The court had set this for a trial at this point based on the affirmative defenses that were asserted in the matter. I believe there's no triable issue. If you look at the answer filed by Ms. Kinkley in the matter, she admits to the non-payment of rent. She admits to the fact that there are damages to the unit. The court is aware there were police reports filed and attached with the complaint that the damages were the result of the defendant herself breaking the windows, refusing access. The landlord is now going to be outside of the certificate of occupancy that was issued because repairs can't be made. They can't get access to the property. It continues to deteriorate. As a result, there's a broken window, broken doors on the interior, broken doors on the exterior. We filed a notice to have this terminated as a result of the health and safety hazard as well as the non-payment of rent, and we'd be asking for a judgment at this time.
Response.
I have it prepared here. I will pull it up.
There is a tree to me.
Okay, this was what I received from attorney with the legal aid, Tracy Jensen. And there are several issues at hand, including procedural defenses. In regards to my written statement and the statements made by Attorney Babnick, the property is not damaged. The pictures that the landlord included, I have countered and included pictures of the house in its current condition. The house was inspected by the Ypsilanti Building Code, Miss Jamaica Berry, in October. In October, I also filed a formal complaint with the city of Ypsilanti through the C-Click Fix notification system, a governmental agency, of the issues with the habitability of the home. I have filed a case with the Fair Housing Administration. There are many things that we could focus on. I would like to focus on the fact that I was denied a disabled parking spot. And according to Michigan Legislature Section 600, and that is 600.5720, says that if it's an alleged termination was intended primarily as a penalty for the defendant's attempt to secure or enforce rights under the lease or agreement or under laws of state, governmental subdivision, or United States, they denied my handicap parking. I filed several complaints at the city level, and I'm defending myself here. The alleged termination, Part B, was intended primarily as a penalty for the defendant's complaint to the governmental authority with a report of the plaintiff's violation of the health or safety code or ordinance. The allegations made by the landlord, I wanted to bring in a third-party perspective. So I contacted the Ypsilanti Building Code Department. Ms. Jamaica came out and did an inspection and found 12 violations on the landlord's, at the landlord's responsibility. In regards to the statement by Attorney Babnick that they have not been allowed to access the unit, that is so false. Her husband, Mitch Carrick, busted down the door, and I was not able to secure the unit.
This isn't the time for me to receive.
I think there are tribal issues, and I can.
Thank you.
Yes,
that's
sir.
all you needed to tell me. And when I look at that, then what I'm going to do is I'm going to do two things today. I'm going to set it for a final settlement conference on this. We'll hash out specifically what issues are going to be litigated. The parties are going to need to be ready to go to trial when I set the trial date thereafter. All right. I'm also going to order regarding escrow, and I'm just going to say this to you, Ms. Kinkley, that you coming into court and posting escrow in $1 bills, this court views as just harassing my clerks and making my clerks go through that process. It is something that I'm not going to tolerate. There is no reason why you have to bring single dollar bills in. You did that when you paid the $111.11. You also did that when you paid $444.44, which my clerks had to count out. You also did that when you paid today the $666.66. So on my own motion, I'm going to order that as you post escrow, that you may only post escrow in denominations of US currency, not less than $10 bills. It is further ordered that from you on this case, because of your abuse of the process, and my clerk's office are ordered that they are ordered to accept no $1 or $5 denominations of US currency for you for the purposes of escrow. And I have signed that order. We will present that to both parties. See everybody on March 19th.
Quickly, can the court tell me what's the registry of the court as far as the escrows?
There is a $111.11 posted by our records. It was posted on January 8th, 2024. On January 10th, 2024, there was posted $780. On January 22nd, 2024, there was posted $1.11. On February 5th, 2024, there was posted $444.44. And I think today, correct?
Yes.
Today, there was posted $666.66.
If I may, Your Honor,
Go ahead.
I just want to establish that I paid the full amount through February and there is a balance ready for March. This is not an issue of paying the rent.
My issue isn't with whether or not you pay rent. It isn't anything like that. Will not be trying to bring singles in, trying to make some point to my clerks. They have nothing to do with whatever the issues are here. They are here trying to serve the public. You will not hand them $600 worth of $1 bills for them to count out. It just won't happen. And I've issued that order.
Would you like any response to that, or we can just move forward?
You can make whatever response you want. I'm just telling you, don't bring any singles in here trying to post escrow. Don't bring any $5 bills trying to post escrow. $10 or higher.
Understood.
That's it.
Going forward, Your Honor.
Is there an adjourned date, Your Honor? I'm sorry, I didn't hear.
March 19th, 2024, 9 a.m. in person.
Your Honor, if I may continue,
Thank you, Your Honor.
if I may.
Go ahead.
Right, so I did confirm with the clerk that all US accepted. Policy does not-
No longer on this case. That is my order. Thank you. I'm done.
We are done. Thank you, Your Honor. I understand. March 19th at what time?
9 a.m.
Thank you, Your Honor. Have a wonderful afternoon.
I will do. You do the same.
I will do my best. I am grateful.
How are you, sir? What's your name?
Carol.
Emily didn't want your case called either.
Yeah.
No, I don't know. I don't know what that's about. I don't know what you did to her.
One of my old attorneys, Fred McDonald, told me don't pay nobody $1 bills.
Fred McDonald was my former partner. Yes.
About money paid.
All right, where are we on this case?
Your Honor, please report Mr. Robertson and I met and we've agreed to a conditional dismissal in this case. Rent to return in the amount of $25.48, court costs of $160. That number, by the way, is through the end of March.
Okay.
$160 in court costs for a total of $27.08. Mr. Robertson's going to pay $25.58 by March 4th and the balance of $160 by April 5th. I did explain to him that partial payment would stay an issue for writ, and we went over MCR 4.201J.
Okay.
Only thing I want to change, your daddy, Your Honor, I'm on fixed income. And if the money don't come on the 4th, I want to make sure that I can pay it on the 5th. Set it as being the 4th, the 5th.
So
That's fine with us.
So you want this changed to March 5th?
Yeah, yes, March 5th.
So when does your check come in?
So I get one on the 1st and one the 3rd.
Got it.
Yeah.
Okay, so it's that
Yeah,
that first payment.
correct.
No problem with changing it to the.
No, sir.
All right. I'm gonna make that correction. Anything else, sir?
No,
All
I
right.
just want to pay him in $1 bill.
Please don't.
Okay.
You don't understand what a sore spot that is. All right.
You guys should be disinfect the $1 bills. I'm telling what
No, I mean, I didn't have to count it. So
Okay.
I had a whole lot of people telling me they did.
Okay.
So, all right. So, sir, any other questions you have regarding
No,
this?
and
condition?
that last payment for the 160 supposed to be when?
Yeah, that's April 5th,
April 4,
which will be that Friday.
5,
So it's March 5th and April 5th.
Okay.
So it's 160.
Okay.
All right. You have 3 business days to think about this from the date of my signing. If you believe that there's some legal reason, some confusion as to your rights or some right you haven't asserted, you'd have to file a motion with the court within that time frame to set this aside. Do you understand that, sir?
Okay, then that's 3 working days. That would be like
3 business days.
3 business. Okay.
I don't think you should be filing it, but you
Okay.
do have that option. Doesn't mean that I'd grant that motion.
All right. Then.
Understand that? All right. Thank you. I'll mark this conditionally dismissed. Thank you.
Thank you.
In this hearing, the court addressed multiple landlord-tenant matters, beginning with a contested termination case in which the plaintiff argued there were no triable issues because the defendant, Ms. Kingley, admitted non-payment of rent and acknowledged damage to the rental unit, damage which the landlord alleged resulted from her own conduct, including broken windows and denied access that prevented repairs and placed the property outside its certificate of occupancy. The landlord sought immediate judgment based on health and safety hazards and continued deterioration of the premises, while the defendant responded by asserting procedural and retaliatory defenses, citing city inspections, formal complaints to municipal authorities, fair housing filings, and Michigan statutory protections against retaliatory evictions following complaints to government agencies. She disputed the landlord's claims of damage and access denial, asserting inspections had identified multiple violations attributable to the landlord and that prior forced entry had compromised her ability to secure the unit, finding that the defendant had raised issues warranting further examination. The judge declined to issue an immediate judgment and instead set the matter for a final settlement conference, with trial to follow if unresolved. The court then addressed an unusual escrow payment issue, sharply admonishing the defendant for repeatedly posting escrow in small denomination, BIL, sometimes hundreds of single-dollar bills, which the court deemed an abuse of process and harassment of court staff. Acting on its own motion, the judge issued a formal order prohibiting the defendant from posting escrow in denominations smaller than $10, directing the clerk's office to refuse $1 and $5 bills in this case going forward, and emphasizing that the issue was not rent payment itself, but the improper manner in which escrow had been tendered. The court confirmed the escrow payment history on the record, scheduled the next hearing for March 19, 2024, and made clear that the order would be strictly enforced. The session then moved to a separate case involving another tenant where the parties reached a conditional dismissal agreement resolving unpaid rent and court costs, totaling $2,708 through the end of March, with structured payments due on March 5th and April 5th to accommodate the tenant's fixed income schedule. The judge approved the modification, warned against partial payments triggering eviction enforcement, reiterated the prohibition on payment in single-dollar bills, and advised the tenant of his limited right to challenge the agreement within 3 business days. The proceedings concluded with the court finalizing the conditional dismissal, underscoring expectations of compliance and reinforcing that while the court remains accessible to resolve disputes, misuse of court procedures, whether through payment tactics or unnecessary escalation, will not be tolerated. For more information, like and subscribe to my channel.
Honor Cheryl Luckoff on behalf of the plaintiff.
Right. Where are we on this one?
So, Your Honor, at the initial hearing, judgment was granted. There are bed bugs in the unit. It's a health hazard. And then Mr. Wazorek filed a motion to set aside the default judgment And it's my understanding from speaking to my client this morning that Mr. Wazurek is planning to vacate the premises. So I'd like to clarify that.
Sure.
Say that again.
You heard,
Yeah, I'm hard of hearing. My hearing, I don't have,
we have equipment if that will help you, sir.
yeah.
All right, let's get that.
I usually wear hearing aids, but my hearing aids are bad. Need to get a new set.
Okay. Let's see. That help you? Can you hear me?
Yeah,
Okay. You filed this motion to set aside the default, but the attorney was asking or had been informed by her client that you were planning on moving out.
I wouldn't plan on moving out. I just asked that if I plan on moving out, I would need more time because I didn't have no time to set up anything. And I wasn't actually wanting to move out. But they were saying I needed to move out. I have made sure all the problems were taken care of in the apartment. I've had Section 8 come in there twice now and check it. Themselves, they haven't checked it at all. They had one guy come in, one maintenance man come in, bring up these charges about garbage being in my house. Well, the garbage wasn't garbage bags. Those were stuff that pots and pans and everything that we had cleaned up and put in that because they told us we needed the cabinets all cleared out. So those weren't garbage bags. Those were all our dishes, food, canned goods, all that. I put them in the garbage bags to be able to clear the cabinets out so they could spray for cockroaches, which we never had to start with. And I had told them that. And they said they were going to, this was on Friday.
Before you go on,
Okay.
because I'm dealing with your motion to set aside the default. Ms. Luckoff, were you present at the previous hearing?
Yes, I was present. I put the proofs on the record with a witness, Your Honor. And what we had put on the record was that on the second, my client's pest control was denied entry because he was not prepared. And then again, the day of court, they were denied entry. And so at that juncture, we did take testimony. And the court established that there was a health hazard, that there are bed bugs that weren't being treated, and that is why the judgment was entered and the immediate order of eviction, which was prayed for in the complaint. So if you'd like me to argue the motion, I can certainly argue it. This has been a chronic problem. There's just a cleanliness issue, and bed bugs, obviously, I don't have to tell the court about the problem with bed bugs. So, I mean, we're looking for possession of the premises, Your Honor. But again, I can argue the merits of the motion as well, if you'd like.
Well, one thing that I'm a bit confused of is that in the defendant's motion, he's saying that, and as I look at the judgment, he's saying that he was there but defaulted.
He was there, but then if I remember correctly, I think he disappeared at one point. And we waited for, yes, because Your Honor, I actually went to a judge's meeting because we wanted to wait to give him time. I went to another Zoom judge's meeting, came back, and he still wasn't there. And that's when Judge Barr entered the judgment.
Your Honor, I was there. They muted me. It was over Zoom and they muted me. So they couldn't get me there because every time I kept saying, Your Honor, I'm here, Your Honor, I'm here, I'm here, I'm here, I'm here. And they just kept saying, you've been muted. And I never got to say a word.
Well, he actually did get to say a word because he did put proofs on as well. And then we ended up.
Well, can I ask if that's the case, why was this judgment by default?
Well, as best I can recollect, because he didn't come back. I think what happened, actually, Your Honor, I believe I had to, and it'd be interesting if we could pull up that transcript because I'm going by my memory here, but I may have needed to get my witness on. And so we took a break. I do remember having to get Wendy on, and then he wasn't there, so we took another break. That's when I went to the judge's meeting, which was at noon. So I think it was, but we did hear from him originally. It's
Yeah,
not that he was
originally
never
the
heard.
first time I was heard, but then they came back. I called the court clerk, asked what was going on with this case, and she told me, well, they're going back in there. And well, I couldn't hear no judge say that they were coming back. And the witness they had,
You mean
Wendy,
they were coming back?
they told me the court clerk told me that he was making a final decision, that I had to get back into Zoom and find out what was going on, because and that's when they couldn't hear me at all. I couldn't be heard at all. So when they brought Wendy in there, I tried to talk. I couldn't. It was totally muted. It was muted on their end, not my end. My son was right there listening. I had him on loudspeaker. He was there listening. He heard the whole thing. I didn't get a chance to say a word. The second time, and Wendy came on there, the assistant manager, and she kept talking, and I kept trying to object, and they couldn't even hear me at all. It was like I wasn't even there. It's like the speaker said, "You've been muted," and I couldn't say a word.
But you're alleging that what you're alleging, which would cause me a bit of concern, is that you were there and that the court muted you.
Exactly.
Okay. Here's what I'm going to do. Your February rent is paid.
Yes.
I'm going to adjourn this to March 1st, 2024 at 10 a.m. In the interim, I'm going to take a look at the video of what transpired.
Okay, I appreciate it.
And Your Honor, if I may, I mean, the issue here is, and I'm totally fine with everything you're saying. I'm not even placing an objection. I just want us all to be clear here, because this is regarding other residents' health, due to bed bugs. So I want to put on the record here, because as you know, I am transparent. They did go in last week. They did treat last week. They have to go back in again next week. So we're still asking for possession of the unit, but I want to make sure we can get back in to treat, just to protect the other residents. So we'll come back. I have no problem with anything the court's doing. That's just, I wanted to put that on.
Okay.
The record.
I got
Yes, Your
you.
Honor, I've never had no objections.
Well, sir, hold on. All I'm saying is you need to let them in so that they can treat the premises. I just want to look at what happened, because if something procedural happened where he was muted, then I've got a different problem than what I may have. All right.
Okay, yeah, because the one time they,
Sir, I'm not hearing what happened. I just need you to let them in so that.
yes,
treat-
I've been doing that.
And then we'll see you next.
Yes,
week.
Your Honor, I've been doing that. I've been letting
Right.
them in. Yes.
Thank you.
In this hearing, the court addressed a motion to set aside a default judgment previously entered in favor of the landlord based on serious health and safety concerns involving bedbug infestation within the rental unit. Plaintiff's counsel explained that judgment had originally been granted after testimony established that pest control had twice been denied entry, creating an ongoing health hazard not only to the unit but to surrounding residents, and that an immediate eviction order had been properly entered. The defendant, Mr. Vierk, disputed the circumstances surrounding the default, asserting that he did not intentionally fail to appear and that during the prior Zoom hearing, he was improperly muted, preventing him from objecting or responding while testimony was presented against him. He further argued that maintenance concerns had been addressed, Section 8 inspections had occurred, and that alleged cleanliness issues were misunderstood, claiming items placed in bags were household goods temporarily removed to allow extermination efforts. The court expressed concern over the allegation that the defendant may have been present but unable to participate due to technical issues, recognizing that such a procedural defect would raise serious due process implications. While the plaintiff emphasized the urgency of continued pest treatment too, protect other residents, and reaffirm the request for possession of the premises. The judge declined to rule immediately and instead adjourned the matter to March 1st, 2024, stating an intent to personally review the prior hearing's video record to determine whether the defendant had been improperly silenced. The court confirmed that February rent had been paid, ordered continued cooperation with pest control access in the interim, and emphasized that treatment must continue regardless of the pending motion due to the public health risk involved. The hearing concluded with the judge making clear that if a procedural error occurred, it would fundamentally alter the posture of the case, but until that determination was made, the priority remains safeguarding health and ensuring lawful process before enforcing any eviction. For more information, like and subscribe to my channel.
Thank you, Your Honor. This is plaintiff's motion to lift the stay, enter an order of eviction, and release all funds that are held in escrow by the court to the plaintiff. This is the way a quick background. This case was filed in October of 2020. This court entered a judgment in November of 2020. However, there was an escrow order put in place at that time because there was a circuit court action that was filed challenging the title. That circuit court action now has been fully disposed of, which I attach as exhibit. My motion were granted plaintiff's motion summary disposition, awarding title to the property to Mr. Tortora. Therefore, since this stay was only until the disposition of that case, which now it has been, I'm asking the court to lift the stay, to enter the order of eviction, and to release all funds held in escrow to plaintiff Patrick Tortora.
Mr. Fair.
Well, Your Honor, we did supplement our answer to the plaintiff's motion to lift stay and to release escrow. As the court may know, the underlying case is currently before the Michigan Court of Appeals. There's a high likelihood of success because that case is about an unsigned agreement between the parties. And there was substantial actions between the parties after this unsigned agreement occurred. And that includes emails. So we believe that there's a high likelihood that this case will be overturned in the Michigan Court of Appeals. So that's really number one. But number two, Judge, you know, with regards to the escrow, my clients have followed the court's order to the T. They have made all the escrow payments. My understanding that they have paid over $115,000 in escrow, and that doesn't even include the $60,000 they paid directly to the plaintiffs in this matter. And the obvious concern, Judge, is that if the Michigan Court of Appeals rules on behalf of my clients, then there is almost impossible, as the court can imagine, that my clients can retrieve this $115,000 from the plaintiff in this matter. I think the prudent course to take, since my clients have complied, since we're talking about a substantial amount of money, since this case is currently before the Michigan Court of Appeals, that the court exercises its discretion and continues with the stay and holds on to the escrow pending the outcome of the Michigan Court of Appeals case. My clients are here today. Obviously, they are extremely concerned about this $115,000 plus that they paid in the escrow. They do want to hold on to their home. They have prosecuted this case. They've continued to prosecute this case, and it is discretionary on the court's part as to whether to continue with the stay. But I will point out to the court that we did go before the circuit court with regards to a stay of the court's decision that was before the Washington Circuit Court. And the judge's position, which is rightly so, that the stay is automatic in the circuit court when you're going to the Michigan Court of Appeals. So from the court's position, it was like, there's no need for a stay. There is a stay. And so we would just ask the court to follow what the circuit court has done with regards to the stay and to exercise its discretion. My clients are here today to show the seriousness in it, and it is a substantial amount of money. So I think this, in our opinion, Judge, and based upon the facts of the case, that we believe there's a high likelihood that the case will be overturned, that the court exercises this jurisdiction, continue with the stay, and hold on to the escrow. And I believe my clients may want to address the court, so I will defer to them at this time.
State your name, please.
Martin Yance.
All right, you need to come to the podium if you would. Go ahead, sir.
Hi,
If you want.
as you know, we've been fighting this for a long time. First, it was with Chase Bank. My wife and I had, really, we paid cash for this house. We built it, took us a year and a half. Our kids, 4 kids, we all worked on that house for a year and a half, got it completed, and it's on 30 acres, beautiful piece of property. The only reason we ever had a mortgage on it is my son had 16 heart surgeries, and we ran out of money. I had to take a mortgage on it. And, you know, this gentleman, Pat Torra, offered to help us. I went to a law firm called Babby Law. There was a gentleman there that was an expertise in real estate. He used to own his own mortgage company. His name was Matt Attard. I had Pat Torra talk to him and make sure all the agreements, the paperwork was right. We agreed on the terms, and this mess happened. I mean, the guy refused to sign. Well, there's an affidavit from him. I don't know if you've ever seen this. Would you like to look at it?
Well, what is it?
It's an affidavit from Matt Attard.
Well, I don't know. I don't know.
Okay.
I don't know that that's necessarily relevant.
Anyhow, he explains how it happened. But anyhow, we're going to fight it, continue to fight it. We'll end up with that piece of property back, I'm assured. I mean, we've never been late. When our mortgage was through Washington Mutual, and they went out of business and went to Chase Bank, we continued making payments. And then Chase Bank called up, it wasn't just us, thousands and thousands of people's loans for no reason. And even though we continued to make the payment, they actually sold our house at sheriff's sale for I think it was $45,000. But it's crazy that we're in this situation. That's our retirement. We have over $1 million wrapped up in that piece of property. That's really all I would say, Judge.
Yeah, if I may add, that affidavit that Mr. Yance was making reference to was the affidavit of an individual who was at the closing for this property with Mr. Torra, the plaintiff in this case. And they were all there, ready to go. All the documents were ready to be signed. And Mr. Torra didn't show up. And so that's what the litigation was about. It is an unsigned agreement. So it's not like they had this oral agreement. It was an agreement that the parties had agreed to, but Mr. Torra didn't show up. And they went forward with the closing. And then after the fact, he refused to sign it. And he did everything in furtherance.
What you need to know, though, is that Mr. Torra's wife owned the closing company, the title company. And I've known her for a long time, and she promised us she would take the paperwork home to her husband that night and he'd sign it. And now we're in this mess because he didn't.
Yeah, and lastly, Judge, what I also point out is that this is not the only time Mr. Torra has done this. The similar, almost identical situation is before Judge Ewell in the Wayne County Circuit Court, where Mr. Torra did the same exact thing in terms of the documentation. So he's got a history of doing this, and it's just highly unfair to allow the escrow to be given to Mr. Torra under these circumstances. And it's not like, he's not, well, Judge, I don't have to tell you about escrow. You know that he will still be in a position of not being harmed as long as the court has the money. And Mr. Yance and Mrs. Yance will continue to make escrow payments.
Thank you.
Ms. Johnson, is there anything you wanted to say, ma'am? Is there anything you wanted to say? You're good? Okay. You're welcome. I guess my question is what harm is there to plaintiff if they're continuing to make payments to the court? And I mean, ultimately, what harm comes to the plaintiff?
The defendants do not reside in the property, Your Honor. It's been abandoned. The concern is for vandalism or any damage or anything else that could happen when you have a residential home that has no one in it and no one looking over it.
I've been going there every day for 5 years. I go there every single day.
But there hasn't been any, hold on, sir, please. But there hasn't been any vandalism or anything. I mean, when you tell me that, that sounds like something speculative that may happen in the future regarding this particular piece of property. And so you should give us some money, and I don't know how that prevents what you're claiming may be a problem.
No more speculative, Your Honor, than Mr. Ferris, or that he thinks there's a high likelihood of success on appeals.
I didn't address Mr. Fair. I'm addressing you. And I'm saying what harm comes to the plaintiff if the court is holding the money pending the final resolution, whenever that may be, of this case.
My client's paying all carrying costs.
He's what?
Paying all the carrying costs.
What costs have they incurred?
Property taxes and insurance.
And how much is that?
I don't have the exact number in front of me, but it is in excess of the escrow payments.
The property taxes?
Yes, because it's not 30 acres and it's a very large residential home.
There's about $115,000 in here. And you're telling me on 30 acres, and I know where the property is located. I know Washtenaw County very well. You're going to tell me the taxes are that?
It's been 4 years, Your Honor.
Hold on. I live on 10 acres. And I'm going to tell you what, if in 4 years, well, I guess we have to triple it. I had $100,000. Not a chance. We're Washtenaw, not Oakland County. Excuse me.
As I referenced, Your Honor, I have not seen the text, but I don't know exactly what.
So you don't know?
I disclosed that before. I do not know the exact number of the taxes.
I just don't. Can you give me any other harm? I mean, these folks are convinced enough in their position that every month they've been paying. I would know. I have what seems like thousands of escrow orders. They haven't missed a heartbeat on any of these payments. It is paid into the court on time. So I don't look at this as something where they're attempting by filing to the Court of Appeals to just delay and string out this matter. And plaintiff wants the escrow, but at some point, the escrow is going to have to be disposed of. That's clear. But I don't understand why now. Why don't we wait until the litigation is finished?
We don't know when that's going to be. And Your Honor's escrow order with this stay was clear that it only went until the circuit court came.
Well, I can issue a new escrow. I mean, but I don't want to do that if plaintiff can show me some reason why I should hold or I should release this to plaintiff when the litigation is not finished.
Your Honor, your order from.
Okay, let's get rid of that, because I'll just change it. If that's your argument. I mean, I'll just change the order. I mean, again, counsel, I am asking just because the court rule in certain respects would require me to try to figure out and dispense with the escrow as justice would require. I'm trying to figure out what harm comes to plaintiff if I don't release it. I get their side. They're actually paying on a piece of property that they don't know in the end if it really is going to be theirs. I mean, they're litigating it, but they don't know. But they're paying faithfully every month. And so I'm trying to figure out what harm comes to plaintiff if it takes the Court of Appeals a year and they're paying. What harm?
As I've mentioned before, it's the carrying costs and then not having the ability to access and use the funds for other purposes.
But I don't know that it will be the plaintiff's to use, do I?
It is a plaintiff's to use.
What, by just your pronouncement? I mean, how do I know in the end of the litigation that it will be plaintiff's, that the escrow would be released to the plaintiff?
Because that goes to the carrying cost of what my client has paid for over the 4 years of the litigation.
If the defendants are successful, where do you think the escrow goes?
My client?
If the defendants are successful?
Yes.
Oh, okay. Well, there may be the part of the problem as to why you think you deserve it. Here's what I'm going to do. I'm not releasing any of the escrow. What I'm going to do is Mr. Fair, you'll prepare an order to this effect that will indicate that the escrow will continue to be paid by the defendants in this case to this court. That the escrow will not even be considered to be released until such time as the highest court that this case is appealed to has ruled. I want it specifically in that language so that everybody doesn't have to come back here running up attorney fees, asking me to do something I'm probably not going to do.
Thank you, Your Honor. Your Honor. This has nothing to do with the case.
Your Honor, I want to make sure it's the same amount. You didn't mention that on the record.
It's the 2,500.
Yes.
Yes, sir.
Years ago, can I ask you a question? Do you remember years ago, a girl on a Friday, I can't remember how many years ago, it was probably 15 years ago, coming in here and asking you were in your chambers, you were the only one left, about a black jet passing her?
A black jet?
Passing her, a car, but she called it a black jet. No, I just wanted to know her name. She came and specifically talked to you. And what it was an alarm went off at my building in Plymouth, and I was speeding to get it. I got pulled over by Washington County. But I passed 3 young ladies from this court. This was 2 o'clock in the morning when the alarm went off. And thank God you were here that Friday, because my court date expired that day and I would have had a warrant out for me for the theft. And she came to you, but I always wanted to thank her, but I don't know who she is.
I can't recall it specifically, sir.
But you got it handled all over the phone. It was pretty cool. Thank you.
Oh, thank you for that.
Okay.
Thanks, Your Honor. I'll prepare the order.
Thank you.
Thank you, sir.
Have a good weekend.
You do the same.
In this hearing, the court considered the plaintiff's motion to lift the stay, enter an order of eviction, and release all escrow funds held by the court, arising from a long-running property dispute that began in October 2020. The plaintiff argued that although a judgment had been entered in November 2020, enforcement was stayed due to a related circuit court action concerning title to the property. That circuit court case has since been fully resolved through summary disposition in favor of the plaintiff, Mr. Torr, and on that basis, the plaintiff requested immediate eviction and release of all escrow funds accumulated during the stay. Defense counsel opposed the motion, explaining that the underlying dispute is now pending before the Michigan Court of Appeals and asserting a high likelihood of reversal due to the existence of an unsigned agreement, subsequent conduct between the parties, and documentary evidence including emails and affidavits related to a failed closing. Defense counsel emphasized that the defendants have strictly complied with every escrow order, paying more than $115,000 into the court in addition to substantial sums paid directly to the plaintiff, and argued that releasing escrow funds now would create an irreparable risk because recovery would be nearly impossible if the appellate court rules in their favor. The defendants personally addressed the court, describing the property as their family home built through years of labor, explaining financial hardship caused by medical expenses, and asserting that the plaintiff failed to appear to finalize the agreed transaction, despite assurances from individuals involved in the closing. The court closely questioned the plaintiff regarding the alleged harm caused by continued escrow, noting that the property has been vacant without vandalism, that speculative future harm was insufficient, and that no clear evidence was presented, showing that escrow release was necessary to prevent immediate injury to the plaintiff. The judge repeatedly emphasized that escrow exists to preserve funds pending final resolution and questioned how the court could determine entitlement before appellate review is complete, finding no compelling justification to release the funds while the appeal remains unresolved. The court denied the plaintiff's request and ordered that escrow payments continue unchanged, directing defense counsel to prepare an order explicitly stating that no escrow funds shall be released until the highest appellate court addressing the case has issued a final ruling. The court concluded that this approach best preserves fairness, prevents unnecessary litigation, and protects both parties' interests until the dispute is fully and finally resolved. For more information, like and subscribe to my channel.